Thank you, Peter. It's my pleasure to be moderating the panel on the politicization of ESG. I'm sure it's going to be a very interesting conversation. My name is Bob Eccles. I'm a visiting professor of management practice at the Said Business School at Oxford University, although I live in Boston. We wanted this panel to be bipartisan, so we thought a good way to do that would be to have two Democrats and two Republicans. So I'm a Democrat, and my good friend Allison Heron-Lee, who you all know, former SEC commissioner, she is also a Democrat. And we have two Republicans, two good friends of mine, Dan Crowley, who is a partner at K&L Gates, and Tim Doyle, who is a senior advisor at the Bipartisan Policy Center. Dan and Tim and I have both written some things together trying to find this middle ground. Dan and Tim did send me a few complaining emails about there's 2 and 2, but I'm the moderator. So is this really going to be a balanced discussion or not? And I thought, well, that's a fair point. But my response to them was, come on, guys, you're lawyers. Allison is a lawyer. I'm not a lawyer. So that's why I'm the moderator and not trying to provide any content on this panel. So it's like 3 lawyers against 1 moderator with a useless PhD in sociology. So that's kind of what the playing field looks like. Maybe the best way to start this, Tim, when you and I were talking a couple of weeks ago, you told me that you were out at the Aspen Institute for a conference. I think it was on ESG or something. Maybe you could just share with us sort of what happened at that conference and some impressions. And I know some issues got brought up around bills, and we're certainly going to want to talk about that. But tell us a little bit about your time at the Aspen Institute in my home state of Colorado. And actually, Allison lives in Colorado as well.
Yeah, thank you, Bob. And, thank you for having me on the panel. It's a pleasure. And it's been obviously great to speak to you in particular, last few months about some of these issues. Yeah, I was fortunate to be invited to go out to Aspen. And as you mentioned, I'm from the Bipartisan Policy Center. So, they really wanted to kind of get a feel for what was going on, or how we kind of saw the political aspect of ESG on both, kind of sides of the aisle. But as you mentioned, I am a Republican. So it turned out to be just me talking about where the Republicans were, because as you can imagine, some of the participants out there just couldn't understand how anybody would be against or be anti-ESG, which is really interesting, because the whole term anti-ESG led us into a discussion about what was going on in the individual states, as I know you and Dan have written about. And so that led to a kind of a back and forth with a participant there about what a particular bill actually said. And my position was, and as a good lawyer, I said, you should really read the bills at the state, because I don't think they say exactly what you claim. They don't really ban ESG. They just put qualifiers on it. And as I was leaving my panel and the next panel was starting, an individual got up and first thing out of his mouth was, well, I did read the House bill that you Republicans put forth, and it bans ESG. And I didn't have much to say about that. So I went back and actually read it. And he was referring to it's HR 4640. It's Congressman Donaldson out of Florida. And we can talk about these bills here in a second. But specifically what this bill did was that with regard to shareholder proposals, it banned or allowed a company to not add or put forth a proposal at an annual meeting that dealt with, and this is where not only I think he was wrong, but apparently I was wrong too, that deals with proposals that were dealt with environmental, social, and political related issues. And that was really the extent of the bill. And of course, as Bob, you and I have talked, I said, well, that seems a little odd that there's no qualifier. Usually, as at least at the individual states, there was always some qualifier that it had to be economically relevant, or it was had to do with pecuniary factors, as we've talked about before. So it was really interesting to reread that. However, in again rereading it, as you gave me some homework to do, I noticed that the title of the bill specifically talked about certain shareholder proposals. So even though the language of the bill banned them all, it seemed like the title really opened it up for future negotiation, if you will, or compromise, where some kind of qualifier would be in there, so that if in fact a proposal it was based on environmental, social, or political issues, did have a financial or economic basis, then it might be it might then be okay. But anyway, I'll leave it at that. It was a very interesting um, exercise going out there, because I felt like both sides have kind of been talking past each other with regard to ESG.
I mean, it's interesting, and we'll certainly get into this because there have been almost in some ways two separate conversations. I mean, when I look back on the hearings in the House that have happened over the past couple months, starting with the Jim Comer hearing, I mean, that just blew my mind. I thought that was just like nutso political theater, in terms of what they were talking about. It was just crazy stuff. I thought that the House Financial Services Committee hearings, I mean, I think they were pretty substantive in the issues that they were talking about. I didn't agree with everything, kind of the positions that they took, but I thought they were substantive as opposed to the Comer hearing. But it ended in a flurry of activity, right? And so it's interesting to have this conversation now, because here we are in August. There's these bills that have been introduced, and then we'll be talking about climate later. And so Congress will reconvene, and we're going to see what happens. Could you kind of give us a quick summary for the audience of what's in these bills, all these different bills out of the House?
Sure. Yeah. And there were, just so people know, there were 19 individual bills that were proposed, and they consolidated them into 4 bills. And so I'll just really briefly go through, because it's a lot of information and it covers the spectrum when it comes to ESG and corporate governance issues, at least from the House Republicans' point of view. So essentially, each of the individual bills of the 19 ended up as titles within each of these 4, if that makes sense. And so for those paying attention or following at home, we'll start with the first, which is HR 4790. This is called the Guardrail Act. And essentially, this deals with 4 different issues, and they're 4 different titles. So Title 1 deals with limiting the SEC to only require disclosure of material information. And this is from Congressman Huizenga. And essentially, it's adding the materiality analysis, Supreme Court definition, if you will, of a materiality analysis. Second, Title 2 deals with requesting, or I guess mandating, the SEC to report their non-material disclosure mandates. Title 3 creates a public company advisory committee to give advice to the SEC consistent with their tripartite mission. Title 4 is a study of the impact, and Bobby and I have talked about this a lot, the impact of the EU's CSDD and the CSRD, and we can get into what those are in a minute. Second bill is HR 4767. This is Protecting America's Retirement Savings from Politics Act. And there's a number here, so a number of titles in here, so I'll go through them. The first few deal with a company's ability to exclude a shareholder's proposal. And this is the one from Florida, from Congressman Donaldson that I just mentioned. So we'll go through this really quickly. Title 1 amends the resubmission threshold. This, believe it or not, has had some bipartisan support in the past. Title 2 redefines some of these two. I should mention these next couple ones are in direct response to a SEC proposal. So in this particular one, it excludes and defines those the exclusions that deal with whether a issue that is brought up in a proposal has been substantially implemented and or is a duplication. Title 3 deals with, as we mentioned before, certain being the term that I mentioned in the title, certain environmental, social, and political shareholder proposals. This allows companies to exclude those. The other then is, and this has gotten, again, a direct response to what the SEC has done. Title 4 deals specifically with the exclusion of a significant social policy issue. And this is, and we can, Allison and others, we can talk about this. It's a 2-part test about whether something can be excluded. Historically, if it's been a significant social policy, it has not been able to be excluded. We'll get into Title 5 here, and this is for the SEC to report on shareholder proposals, proxy advisors, and the proxy process. Title 6 deals with, and this is actually a fairly rigorous a title in the bill. This is the registration of proxy advisory firms, another issue that has historically had some bipartisan support. Title VII deals with proxy advisor liability and what their failure to disclose material information about their voting advice. Title VIII is voting duties of investment advisors, asset managers, and pension funds. This is from Congressman Loudermilk originally. And this one, I will say, Bob, of all of the ones that are in here, based on the way it's written, this probably has had the most input from industry, call it lobbyists, if you will, based on the language in here. Title IX, prohibiting robo-voting or automatic voting and outsourcing, and in particular, and some of Allison's former colleagues have indicated this, that there's not a requirement to vote every share. So they've actually put this in that particular bill. And two more here in this one. Title X deals with passive funds, in particular, that an asset manager must follow the management's recommendation unless a beneficial owner has otherwise told them to go in another way, or it allows them to abstain. And Title 11 here deals with the best interest rule. Essentially, this is this word that the Scalia Department of Labor started to using, and they got it from the Supreme Court ruling. Of course, we talk about that as well. But it essentially says that the best interest shall be based on pecuniary factors unless consent to do something else. And oddly, it has something in here, and maybe Allison or some others can talk about it. There are a couple of studies dealing with the municipal bond market that seemed a little out of place here, but I'll have to look into that a little bit more and get back to you. So now we'll go on to the third of the four, and then this is just HR 4655. This was an interesting one. This essentially says the legislation clarifies that the SEC, and Allison, I know you probably disagree with this one, the SEC does not have the power to regulate shareholder proposals through Rule 14A8, which I thought was pretty interesting. And this bill is this one is interesting in particular because it really makes titles 1 through 4 of the previous bill unnecessary, given the way it's written. And then lastly is HR 4823. This is the American Financial Institution Regulatory Sovereignty and Transparency Act. Sometimes the staff like to make these bills have acronyms, and so this acronym of a bill is America First Act. This is Congressman Loudermilk. So there's 4 things that it does here. Title I, essentially, it is not only the Federal Reserve, the Office of Comptroller of Currency, FDIC, NCUA, and FHFA. It requires a notice of recommendations, a report and testimony when FSOC, especially when they're responding to something that the FSOC's done. Title II is, again, this has to do with the Board of Governors of the Federal Reserve, prohibits rules from these same agencies I just mentioned, unless there's notice, testimony, and an economic analysis. Title III deals with record keeping, discount lending, and supervisory policies. And finally, Title IV of this removes supervision and implements the full power of the chair. Essentially, this allows the vice chair to become the chair without the terminology of supervision. At least that's my reading of it. And Bob, that was a mouthful there, but that is a summary of the 19 bills that were just passed.
Well, thanks for the summary, because I don't plan to read all the bills, but I mean, you guys have been busy, man. 19 different bills packaged up into 4, and kind of the themes that come through to me in this are sort of materiality, shareholder proposals, proxy voting, some more technical stuff. Maybe I vaguely hear this major questions doctrine lurking in the background a little bit around SEC authority. We'll get into that in more detail when we talk about the climate disclosure rule. So hanging around with you, hanging around with Dan, you denizens of the swamp, and then Allison spent years in DC at the SEC. I've learned the term messaging bills, right? There's bills that people want to pass, and then there's messaging bills. So Dan, you're an astute observer of the Washington scene. like what are these bills? Are these bills that we're going to try and get some bipartisan support on things like materiality? Or are these just messaging bills because they can do it because it's fun because you guys have got the majority?
Yes. No, seriously. I think, they started out as one thing, and as the process has played out, they've morphed into something entirely different, which is to say that each of the individual bills has merit, and the ones that were marked up, particularly mandatory materiality. You and I have both endorsed that concept in writing a couple of different times. I think that was quite possibly a bipartisan bill in the making. But for whatever reason, as Tim just did a great job of outlining, these bills were cobbled together in such a way that seems designed to preclude bipartisan support. So, for example, on the first bill that Tim went through, the Guardrail Act, the cornerstone of that is the Mandatory Materiality Requirements Act that Bill Huizenga and Andy Barr and others had introduced. But when they put it together in the Guardrail Act, they stuck on bills by Congressman Mooney, Lucas, and Musier. Each one of them is more controversial. And it's interesting now, the four sponsors of the Guardrail Act are Huizenga, Musier, Lucas, and Mooney, no Democrats. And that's the case with each of these. And I think the reason is that Patrick McHenry is a very sophisticated operator. He is not someone who just asserts committee jurisdiction because he can, as is the case with the House Oversight Committee and the House Judiciary Committee. I think they're trying to cram ESG into their jurisdictional prerogatives, whether it makes sense or not. Whereas Patrick McHenry, who actually has jurisdiction over the SEC, has taken a much more thoughtful approach. And after reviewing the entire waterfront of potential issues, they've essentially distilled it into three buckets. The 14A8 process, which are the SEC rules governing the proxy voting process, the regulation of proxy advisors, and whether there should be more competition in that space, but at a minimum, the bills would require registration and record keeping and essentially regulate proxy advisors for the first time. And then the third area is this whole question of how proxies are being voted on behalf of beneficial owners, particularly for large index funds, where the person voting the proxies may not even know the the investor. And so they focused in those three areas, and I think that's going to be the messaging going into the 2024 election is on the need to reform the proxy voting process. And they plan to take these bills to the floor. I have no doubt they will pass the House, and then that's where it ends. There's zero chance. Now, some of these bills, interestingly, and I know Chairman McHenry will have gone through this calculus, but some of the bills could have passed the Senate. And the reason I say that is that when the DOL guidance was subject to a joint resolution for disapproval, it passed the Senate with 2 Democratic votes. Tester and who was the other one? Yeah, that's right. Tester and Manchin voted against it. It forced the first presidential veto in Biden's administration, and they clearly did not have the votes to override the veto. But the fact that that bill got 2 Senate votes tells you that similar rifle shot legislative initiatives probably could have passed the Senate. I think part of the reason the bills were packaged in the way that they were is to prevent that eventuality, because that would essentially take away the issue, and the idea is to use this going into 2024.
So going into 2024 to make it basically something to continue to campaign on, that there's this anti-ESG movement and it kind of mobilizes the base and raising money. Is that?
Yeah, and you know, the other bucket, of course, is the equity agenda, right? Everybody was fine with diversity and inclusion, so progressives had to go a step further and throw equity into it, which is an inherently redistributionist concept. And so the Republicans intend to position ESG in the same vein, thinly veiled Marxism, for lack of a better term. But that's the fight. And in a very real way, the ESG battles are a proxy war for that much broader fight on the role of government.
I mean, it's interesting. I'm going to turn it to Allison. As a taxpaying American citizen, I'm both, bemused and a little frustrated with how things work in Washington. You could have had a bipartisan bill, and they chose not to do it. And I'm sure it happens the other way around. I mean, I think that the Jim Jordan, Jim Comer kind of Freedom Caucus crowd is like, out there in outer space in a lot of ways on this stuff. I think McHenry and Isaac and stuff understand, what the issues are. There's a part of me, to be honest, that kind of, when I watch these hearings, I mean, I wonder if either side really wants a resolution. I mean, there's the benefits to the Republicans with the anti-ESG stuff, Dan, as you described, and kind of my guys, they get to look like, the pro-business, pro-capitalist, pro-free markets, in the room, by saying, here's what ESG is. And so I guess there's a question in my mind whether there's an appetite on either side in DC, given how polarized, this country has become, to try and get some resolution on this. But Allison, let me turn it over to you. I mean, kind of what's your take on these bills, the process? Where do you see this going? Should we be optimistic or pessimistic around these ESG issues? What's your take?
Well, let me say a couple of things in response to what I just heard. I want to start with the topic, the notion that DEI, diversity, equity, and inclusion, that you can pull out a piece of that and refer to it as thinly veiled marks. That's a discussion that I think is another hour's worth of so I'm not gonna. I have to call that out as, I think, a false premise, but I'll set that aside because I think we want to try to find places where we agree, and I think that's a really worthwhile endeavor. It's certainly something I tried to do when I was at the SEC. Let me take a couple of big picture issues here. The materiality piece, I think, is really important, and this is an area that I have focused on, and I'm actually in the process of writing a speech on right now to kind of take it a little bit further. But I have focused, and actually for 20 plus years as a securities lawyer, focused on materiality and what it means. So the idea that we need legislation that would say we're going to mandate materiality, I believe that is a little bit of a sideshow, because I know of no place in the SEC anywhere in the regulatory regime where you can identify and say this is not material but nevertheless required. I think what happens with the talking points there, or the discussion, is the difference between whether a topic is material to investors, a topic like executive compensation, like potentially some of the issues that fall under the ESG rubric and the like, and whether the SEC should say within this topic that we know is important to investors, here are the things we need to see from you in order to make it comparable, to make it consistent, to make it reliable. If all we say is, if it's material, then disclose it, which I think we all know by now that's not the way the securities laws are written. If we say that, time and again, we see that assessment does not get made in a way that's consistent across industries enough to allow investors to kind of really compare and price risk. So I think a very recent example of that comes from the cyber release that we just saw, where they said, look, we've tried to issue guidance. We've tried to say if it's material, you should disclose it. And we haven't gotten sufficient information into the markets on this point. So the question really to me is not, is the SEC focused on materiality, but rather, what are the details around a particular topic that ought to be potentially disclosed? Those are the discussions I think are well worth having, and we do. And those are the discussions where I think we need to focus carefully on the economics as we're drilling down and the like. But we can't simply back up and say, if you think it's material, you should disclose it, and then just all go home and decide companies are going to do that. The other thing about materiality that I think escapes notice a lot is it's to be viewed through the lens of investors. The Supreme Court's very clear about that. It's what is important to a reasonable investor, but the decision is not made by investors. The decision is made by management. So there's a bit of a breakdown there too, and you can't ignore that. You have to think about, how is this going to play out when someone else is interpreting what's important to another entire group? You need to listen to both sides and think about it. So the materiality piece, I think there's plenty of room for discussion, for trying to find ways to agree on what within a particular topic is material. But if you think the entire topic is not material, that's a different discussion. I think it's a hard one to make when it comes to some of the issues with respect to ESG, not all of them, plenty of them, because it's such a broad umbrella and it's so kind of vaguely defined. There are plenty of places in there where I would think to myself, in general, to capital markets, that may not be material topic, but not climate. And then the last piece on the materiality thing I want to say is, I do take the point that you want to do a study. So I don't necessarily think it makes sense to view with suspicion what's happening globally in this space. We have to cooperate. We're basically required by law and by just common sense to cooperate and coordinate with international regulators. We have a global economy and we have massive global firms, so we should be doing that. But if you look, if I'm not mistaken, and Tim, you looked at this much more deeply than any of us, which thank you for that. But when it talks about doing a study of the impact of CSSD and CSRD, doesn't it say the detrimental impact? Isn't that what's written into the language of the law? So it presumes an outcome for, that it presumes the impact is detrimental and then just says, tell us how detrimental. That's not really, in my view, kind of a good starting point for doing an economic study and for taxing the resources of the SEC. So there's my rant on materiality. Let me switch to the 14A8 stuff. I do think there's more room there potentially when it comes to proxy advisors. Plenty of places where I think we could probably find some common ground. And one of them, so I have long been deeply concerned at the duopoly there. That is not a good situation for capital markets to be in any space. We have that problem in the stock exchange space. I don't see a lot of uproar over it, but it's a real problem. And we have that problem in the proxy advisory space. The other piece there is Broadridge and the proxy plumbing process. That's like a 90+%. That's a monopoly, not even just a duopoly. So a lot of those places, I think, require some attention. And I would be, if I were still at the commission, I would be very pleased to try to help with that. I would also, I'll tell you what I think we missed. And we've done 2 rounds of rulemaking over the last, few years in the prior administration and this one related to proxy advisors. I still don't think we got the conflict of interest disclosures and potential prohibitions right. And I would have supported a deeper dive on that and a greater lens around conflict disclosures, because there are conflicts there. I'm not suggesting they're nefarious. I'm not suggesting but it is a fact because of the way that they advise corporations and then turn around and deal with recommending the voting. So I think there's room there. I would love to see an exploration of that. I don't think the registration piece, could we use the fiduciary regime? Could we use 206 and investment advisory? Is that sufficient? Maybe, maybe not. I would not necessarily be opposed to the registration piece, but as I looked more closely at the dive there, the level of substantive input they would require from the SEC did not make sense to me. We're not in the business of judging the merits of the decisions that any of our registrants make, period. And so to introduce that piece does not make sense to me. But the registration regime, potentially, yes. Problem there, of course, is adding in cost when you're trying to increase competition, something we always wrestle with, in these spaces. But to me, that might be the most promising place. The resubmission thresholds, we did already increase the resubmission thresholds there, and we have decades of patterns to observe about how long it takes to build support. And the fact that shareholders are frequently the harbingers of good governance ideas, that's where many of them start. A lot of good work in there on classified boards, on special meeting percentages. A lot of those things, which people now take for granted, were introduced by shareholders. But had they faced the kind of resubmission thresholds that are proposed in this legislation, we may not have seen those level of improvements for decades past the time that shareholders could see it. So I I'm not a fan of going further. I really felt like it was pushing the limits a little bit with the last one, but I think where we are is reasonable, and I don't think I could support increasing those. Again, I think it's been pretty well documented that value is added by by shareholders kind of raising the specter of the need for change in very specific areas. I don't want to go on too long. I want to add one last piece. I think it would be a big shock to the Congress of 1940 to determine that the SEC has no power to regulate. I mean, okay, but it's been there for a long time. The question of whether the SEC should be involved on a daily basis in determining what could or could not be excluded, that's long been up for debate. I would love to see a solution there. I don't love the SEC involvement, but here's what's interesting on that piece. Anytime there's real discussion about potentially disinvolving the SEC in analyzing whether a shareholder proposal can or should be excluded, both sides of the aisle come back and say, no, we want you in this process. They want some level of assurance. Issuers want us to be able to say, okay, we're not going to sue you. And to be clear, we don't prohibit on either end. They can do whatever they want. We simply say, if you choose to exclude this, we won't recommend an enforcement action. It's not quite as direct as people think, but nevertheless, it's a huge tax of SEC resources. And maybe there's some bipartisan way to shift that in a way that would help and work for both sides. So let me stop there.
So, let me just quick reaction, and I want to get comments from Dan and Tim on this. It sounds like you're saying, tell me if I've got this right, that trying to get some common ground on materiality is a general notion. There's probably not much purchase in that. What we need to be doing is focus on particular topics as to whether they're material or not. Did I hear that right?
Yeah,
Allison?
I suppose that's right. Yeah.
I'm not a lawyer, so I'm simplifying it for all these accountants out there that are listening to this, and they aren't lawyers either. The second thing is, it does sound like there's some opportunities for some bipartisan resolution of issues that have been kind of burbling around for a while. Can you imagine that happening, whatever the outcome is of the presidential election, or is this just a war that's got to go on for a while because, both sides want it to or whatever? Can we ever get some resolution on these issues, like the, duopoly of the proxy advisory?
I think that
firms?
might be the most hopeful place. I mean, I'd love to hear from Dan and Tim on that, but I think that might be a place where there's a more of a willingness to try to find some deeper solutions there. But I think it needs to also be accompanied by focus and attention on the other issues within the proxy plumbing area that need attention, like Broadridge.
The Broadridge, it's interesting that I was always struck by the fact that they've got 90% market share, and they don't show up in any of these discussions by anybody, as far as I can tell. I think that raising that is really good. But, Tim, Dan, let me give you a chance to respond to what Allison said and what's your view on whether there's some potential here around the proxy advisory issue.
Regarding proxy, or Allison covered a lot. So
wherever you want to pick it up, there's an open discussion.
I'd like to materiality. And Allison, I know you had a speech back in 2021 was very interesting, kind of your take, and I'm really interested in seeing what you're working on now when it comes to that. But so I believe, based on not only talking to some of the congressional staff and Congressman Huizinga, I think their biggest concern is they want to take the idea that the SEC would determine what was material, away from them and put it back to the boardrooms, and make it more about the relationship between the board and their investors, as opposed to the SEC coming in and saying, hey, we've received all these comment letters from all these various groups of investors, and therefore we are determining something is material. And I know you brought up, which is very interesting, the executive pay. I also think they want to distinguish, and Congress does not like it in general when agencies step in their ground, so to speak. And I think that's some of that's coming out in here, where they're essentially saying, we will tell you, SEC, when something or when we want you to specifically say something is material, like conflict minerals, for instance, or executive pay. And as a result of that, until you do that, it really is it is really a decision made by the board in consultation with their investors. So I think that's what they're trying to get. And you're right, Dan, I totally agree with you that by packaging some of these other bills within that larger bill, I'm not saying it would be a poison pill. And having talked to some of the staff there, I think in their and I know, Dan, you mentioned that you think that the bills were kind of almost dead on arrival in the House, so to speak, in the sense that they didn't want bipartisan support because they kind of knew what was going to go on in the Senate. Some of the feedback I've gotten is actually quite the reverse. What they essentially, I think, are thinking is we're going to put our kind of like our statement out there about the issues we think are important, realizing that this Congress is not going to get the kind of bipartisan support that we'd want. However, we want a starting point kind of going forward in 2024. So that's the feedback I got. And because Bob, you mentioned messaging bills. And they essentially specifically said, Tim, these aren't messaging bills. And Dan, you love this. My response was, well, then why are they written? Why are they written the way that they're written? Why aren't you talking to Democrats and getting them, on board? But that's a separate issue. But materiality, I think, is for a lot of Republicans on the committee, and a lot of issuers for that matter, is a very, very important issue to be resolved. And I know we're going to talk about the climate rule in a second. I think it probably comes out there more than anything else. And I know I don't want to jump the gun here and move into that, but I also completely agree with you. Materiality is just it's vitally important kind of to get right, and I do think there's some bipartisanship. Proxy advisors in general, I agree, is the most bipartisan topic, if you will. And if we can just kind of get together, and the political environment may not be there yet for them to do that. But it clearly, based on some of the conflicts you're talking about, at least at ISS and others, of course, at Glass Lewis, the conflicts is a huge issue. How they're coming up with their recommendations is another. So I really think that that's probably a huge area. And I will add this, and last point is when these bills came up in front of the House, I actually was fortunate enough that they asked me to come testify, and not about the specific bills, as I just mentioned earlier on this program, but what were the bipartisan ideas behind some of these bills? Because they knew that they weren't getting bipartisan support for these bills, but it was the ideas that a lot of these bills were based on or historically had that I was able to talk about a little bit when I testified in front of the committee. And Dan, I'll turn it over to you.
Well, sure. First of all, I agree with your assessment that, I think from the committee council perspective, they're trying to position the legislation so that if 2024 results in a sweep with, President Trump getting reelected and both chambers going Republican, then they've got an agenda. But in that circumstance, you have to ask, are these the bills they would pass? Because I think I have never seen a bigger disconnect between the political rhetoric and the policy reality on any issue I've worked on in the last 30 years, And, Patrick McHenry in particular is sophisticated enough to know that absent legislation, the regulators are going to move forward on the current path, right? So if you were really trying to redirect the regulators, you would want a bipartisan, bicameral agreement that would help steer. They've chosen not to do that for a couple of reasons. One is they think the current climate risk disclosure rule is fatally flawed and will not survive judicial scrutiny, so they don't really need to focus on fixing it legislatively. And secondly is this sort of tacit understanding that the markets are evolving in a certain way on both sides of the Atlantic, almost regardless of what the regulators do. And the way I've put it in a recent presentation to the federal bank examiners is that the European regulators are ahead of their markets trying to establish policy, and the markets are trying to catch up. And the U.S. regulators are playing catch up to where their markets already are. And I think that the House Financial Services Committee members in particular are aware of that dynamic and are more or less comfortable allowing the SEC to move forward, recognizing that they're going to have to make changes, and we can get into scope 3 and that sort of thing. But I think their goal is to pass something for messaging purposes to be used in 2024. If President Trump is reelected, there very clearly will be an America First agenda, and this package of bills fits with that very nicely. I still doubt, even if Republicans had the ability to enact legislation, whether these are the bills that would be passed.
Yeah, I guess, Dan, just to that point, I would say that, at least based on talking to committee staff, is that these bills would be open to compromise, but they've repeatedly told me that these are these are the starting point. So I think, for instance, particularly, I bring up that bill from Congressman Donaldson about prohibiting ESNP, not GEP, that is ripe for a compromise, to add some kind of economic qualifier to that. So in talking to them, I know that that's what they're thinking of, but you also, and again, I appreciate this and I know you appreciate this, is they jammed 19 bills through, right? I mean, they were, there was probably nothing stopping this train. And so they thought, you know what, we're going to put everything in there that we want. And we'll, when we come back and compromise later, post 2024, and I agree with you, they certainly can use this for the 2024 election. But everyone that I've talked to in the committee believes that these bills are open to compromise, at least in some aspects.
So let's do this. We've got about 20 minutes left, and so it's now time to talk about climate. It gets into materiality, it gets into the SEC's authority, it gets into the points you made, Dan, around the U.S. regulators maybe, trying to catch up with the markets, the European being ahead of it. We'll see what happens with the SEC's, disclosure, rule when it comes out. The International Sustainability Standards Board already has a climate disclosure rule. EFRAG, you've got their European Sustainability Reporting Standards. CSRD, as we all know, companies, as Allison pointed out, will have to be in adherence to it. So there's regulations already taking place around the world around climate disclosure, and we're going to have one out of the SEC. And then this seems to be sort of the center of a lot of this debate around the SEC's authority. Now, Dan, you think it won't survive judicial scrutiny? So that's whatever this, help me with that, then I'd like to, because Allison was in on this really from the beginning. So I'd like your perspective, Dan, and I want to flip it over to Allison.
Yeah, well, first of all, I don't think there's any doubt that the SEC has very clear statutory authority to promulgate corporate risk disclosure regulations. They've got it in the 33 Act, the 34 Act, the 40 Acts, etc. I think the only question is whether Scope 3 goes beyond that statutory delegation of authority. And under EPA, Bob, I'm sorry, I can see your lips moving, but I can't hear you.
Scope 1 and 2 were
yes. I think Scope 1 and 2 are consistent with the SEC's.
But the Republicans are pushing back even on Scope 1.
Oh, I know. I think they're wrong. I think the only real question is whether Scope 3 is a bridge too far, because it gets into externalities which are not really related in the minds of Republicans on the Hill to material risks facing investors. And I think that the SEC itself is struggling with that. I think they've got an internal split. And that's coupled with the concern that if there are modifications to Scope 3, it'll create difficulty. There won't be mutual recognition with the European regime, so there won't be substituted compliance. And so I think that's the other side of the coin. One is, how do we dot the I's and cross the T's to survive judicial scrutiny? And then two is, how do we have substituted compliance with the Europeans? And I'm not sure that you can solve both challenges in one rule. My gut tells me that they will make modifications to the Scope 3 requirements, either a delayed implementation or some sort of other modification that allows it to move forward, so that they've got, it's like playing football. You don't try to throw a touchdown on every pass. They just need to move the ball downfield and live to fight another day, get a first down, and maybe modify it going forward. So if I were advising the chairman, I would say, get what you can get now, survive judicial scrutiny, and then modify it as needed later to deal with the regulatory disparities, or turn to a private sector solution, which I think is the most likely outcome here, is that the U.S. will end up where it ends up, the EU will end up where it ends up, and it will be up to the corporate disclosure regime to bridge that gap.
So Allison, really, it's under your leadership, that we have this rule, so I couldn't ask for a deeper expert on the topic. You and I have had some discussions about this as well. What's your take on what's going on?
Well, let me start by addressing what Dan just was discussing, because I think it's really one of the most central issues that the SEC is wrestling with, that capital markets are wrestling with, and that is what to do with Scope 3 and whether it makes sense and the understanding that we do have Scope 3 now, coming out of the EU and the ISSB, which potentially is going to start to be adopted by jurisdictions around the world. But I want to ask you, Dan, you said something along the lines, and I don't want to put words in your mouth if I've said it wrong. You said something along the lines of, clearly the SEC has jurisdiction over corporate risk in the 33, 34, and 40 Act. Of course, those acts don't use that term, but I think I know what you mean, which is the SEC has jurisdiction to create rules that allow investors to analyze the risk associated with their investments. And so here's the thing about Scope 3 that I'd love to hear from you on, and that is, as I look at Scopes 1, 2, and 3, arguably Scope 3 deals much more directly with corporate risk than Scopes 1 and 2. Scopes 1 and 2, of course, Scopes 1 is just what are you creating in your own business and in the making of your products, the delivery of your services, whatever it is. Scope 2, the same thing. How much are you buying in order to do that? So there's a level at which those two scopes actually look a little bit more like the European model of what is your impact on the environment versus what is the environment's impact on your enterprise value. Scope 3 is supply chain, up and down. So to me, it's actually more focused on the risks a company faces. We see this too in the private ordering on this piece. You've got huge companies like Walmart and the like who have campaigns in place designed to allow and teach and educate and require, in some cases, their suppliers and vendors on both sides to actually reduce the emissions associated with what they're selling and buying from Walmart. And they're not the only ones. And the reason, again, that is arguably much more directly related. So when I think about a rule that goes up, now the Supreme Court, if it's going to use the major questions doctrine, that's a relatively new doctrine. We don't have decades of precedent to read through and think through. We have a little bit more now than we did, maybe 2 years ago. So they can do whatever they want essentially with that. And if it ends up just being a philosophical divide and they decide they don't like it, that's one thing. But if you're really looking closely at the legal issues, for example, with Scope 3, that's the majority of emissions worldwide. The largest emitters, the majority of their emissions are in Scope 3. So if it's material, if it's a topic that's material, and if it's something that you think investors need, does it not detract from your argument to say, but we are going to exclude the majority of that in our, doesn't that undercut the notion? And then secondly, again, I think it's pretty critical to think about a rule that has only Scopes 1 and 2. I'm not talking about a rule that omits greenhouse gas emissions. We could set that aside for a minute. But if you have a rule that says 1 and 2 only and no 3, I think it's actually higher litigation risk, not higher political risk. That's a different question, but higher litigation risk in the legal analysis of which one of these is more closely and directly related to enterprise value and corporate risk of the 3. So I want to say that, but I'd love to hear your thinking on that, Dan.
Well, sure. First of all, I think, the Scope 3 comes closest to the European notion of double materiality. And by that, I mean, they distinguish between financial materiality and impact materiality. And what I'm suggesting with sort of the EPA versus West Virginia analysis with respect to the SEC is that their authority very clearly goes to financial materiality. not impact materiality. And Republicans would argue that impact materiality on greenhouse gas emissions is the province of the EPA, not the SEC. And so that's the argument. But I hear what you're saying too, and I would just add that, the impact on investors will vary significantly by industry, right? And there will be some industries where it's far more material than others. Obviously, oil and gas is the biggest greenhouse gas producer, and it would presumably be far more material there. I'm not an expert on where to draw the line, which is why this is the subject of almost certain litigation. And I think from the standpoint of the SEC, they just have to live to fight another day, because frankly, this is the biggest rule of the administration across the board, across the agencies. This is it. And they simply can't afford to lose. And so I expect that's why it's taken so long to finalize it. When it gets to timing, I actually had an opportunity to hear Chairman Gensler at the National Press Club about 3 weeks ago, and a reporter asked him specifically about the timing now that the climate risk disclosure rule is on the RegFlex agenda for October. And he said, look, when we're told to provide estimates, we're only given October and April. So they're just guesses. We don't know. It could be, again, we could be talking about it again next April. But they had, for example, the private fund advisor rule on the agenda for October. And then last week they noticed that they're going to be considering it next week. So it's more than a month early. And I don't know if that indicates that the logjam is breaking and we should expect to see more activity. But I don't, the long and short of it is I don't think you can rely on October as the be-all, end-all release date here. But Allison, I'd love to know your thinking on the actual timing.
Well, yeah, Dan, because I heard September.
Well, so Gary is right, and this is just it's amazing how many times we have to sort of try to tell the media and help them understand that RegFlex just says April and October. So and as you know, rules roll out every month, sometimes every week. So I don't regard the private funds rule as early. It's just the next in line. They are just rolling them out. And that's, if you look at the cadence, if you look on the website and you see, they just every month they're coming out. The whole notion of April and October is those are the only choices. And what we're saying is the goal is to get something out by then. We hope to, but it's either going to be a proposal or a final, and those are on two different lists, and we'll see. So I don't view necessarily missing an April or October deadline as a delay, because sometimes it's very sound and prudent to wait and make sure you have all the right data, you've really thought it through and that type of thing. But on climate, couple things. What we know is that you all, I'm sure, are familiar with the CRA, the Congressional Review Act. That creates a deadline of sorts, right? Because that, just for the folks listening who may not be familiar with it, there's a procedural rule that would allow a new Congress, and you'd have to have both houses and the White House to do this, but that could happen, right? To just withdraw any rule that has been finalized within, I think, the last 60 days of a legislative session. The problem with that deadline is one never knows where it's going to be, because you don't know what the legislative calendar is going to look like. So what do you have to do if you're going to be focused on that? You have to take the most conservative estimate you possibly can, and say that, we can't let anything go past this unless we are, that we think might be concerned, somehow be a subject of a CRA. That most conservative deadline by most estimates is roughly April of next year. So my view is you will not see it go past that. Like, that's kind of the outer edge, I think, of the timing on this rule. I think most of us hope that it won't get anywhere near that, but I don't think that April will come and go with no rule. April of next year. That's the latest. In terms of the current, when between now and then, of course, I have no idea, but I know enough unfortunately, about how things work internally, that if there were active negotiations and if there were paper on the desks of the commissioners, that would most likely leak, and we would all know that. And we haven't seen anything to suggest that those negotiations are going on, that there's paper, that there's a draft, that people are dealing with it. I'm not going to speculate about why that's the case, but I feel pretty sure that it's not. I'd be amazed if something with this level of focus and the like, there wouldn't be a leak of some sort. Again, unfortunate, but historically pretty routine. So I don't think they're in that process right now of looking at paper and trying to negotiate a resolution. I don't know why, but to me that implies that process is going to be difficult. It's going to be intense. It's going to require a lot of focus, and it's going to take time. So if the paper was on their desks today, I still would think it would be hard to get to a final by October, but maybe.
So we've got about 5 minutes left. I want to give you all some time for closing comments. But Tim, do you want to weigh in on the climate thing, and maybe for the accountants, just briefly describe what this major questions doctrine is for our accounting friends out there?
Yeah, sure. We won't obviously have time to respond to this initial comment I have, which is, Dan, you'll appreciate this. Allison, you won't. Scope 3 is not the only reason why I think that the climate rule will be challenged and litigated. There are other aspects that deal with materiality, for instance, that I think will be litigated. Scope 3, I think, is just the one that probably most people think is the most likely that the court will hang their hat on. But I do think that there are other ones. And one of which, of course, is the major questions doctrine. And as Dan and Allison mentioned, Allison in particular, the court, this is a relatively new, the concept, I suppose, isn't new. It's relatively, its application is more recent, shall we say. And that's a two-part test. And essentially the two-part test is that it's that the issue being reviewed, so we'll talk at a rule that comes out that's being reviewed, has to be an issue of major national significance, political and or economic. Is one, that's part one of the test. And then the second is whether there's clear congressional authorization to do that. And then there are a couple of factors to look at when you apply that two-part test. One is it a new problem? Is this a new issue? And the statutory authority that the agency is using, is it infrequently used, or does it deviate from past practice? And then, of course, the last one, which is for the second part, is whether it's significant or will have political repercussions. So I think with Allison, I think you're absolutely right. If the current court applies the major questions doctrine to for instance, a rule such as the climate rule, I suspect, based on their rulings thus far, that the rule could be struck down based just on that, without even going too much into the specifics. Based on a number of factors, Scope 3 being, of course, the most at the top of the list. But as I mentioned, there are other aspects of this. A lot of people call it, the climate disclosure rule, but it does more than require companies just disclose certain data. It asks company to come up with how they're going to address the data that they've disclosed. And I think that that's where that materiality starts coming in. As one of your former, Allison, your former colleague, Hester Peirce, has indicated that, some aspects of this rule, that they've just stripped the materiality analysis entirely from it. And so, as I mentioned, I think there are a number of different issues. I am not only incredibly interested in seeing what this rule will look like, whether Scope 3 or others or other aspects are in it, but I'm really, really, of course, interested in how the courts are going to interpret this.
So I'm going to beg Peter to give us maybe 3 extra minutes or something. Since I'm the moderator, I'm going to throw a grenade into this that you don't have to respond to at the end, and we're going to get sort of wrap up comments. And here's a grenade, and it kind of goes to the point that you were making, Dan, around kind of regulation versus market adoption. So the ISSB's got Scope 3, and FRAG's ESRS has Scope 3, and the CSRD is going to be required of U.S. companies who've got 250 million euros in revenues, which is a pretty low bar in Europe. Confidentially, I know of a major U.S. company in a very controversial sector that is, absolutely focused on being prepared to report according to the CSRD without, kind of thinking there'd be some kind of equivalence like you and I have been talking about, Dan, with ISSB and GRI. So it'll be very interesting for me to see whatever the regulation turns out to be, what the impact is on corporate behavior. Because my guess is, I think you're going to have a lot of the major multinational companies reporting on Scope 3 anyway. That's my grenade. But we're coming to the end. So, Peter, please give us a few more minutes. I'd love to give everybody a chance to wrap it up, maybe with one question, then add whatever you want. The question is, the topic is the politicization of ESG. Is this going to continue for a while, or do you think we're going to fairly quickly get down to particular issues rather than the CSG term? And then whatever final reflections you have. And Dan, we'll do it in alphabetical order. We're going to start with you. We'll go to Tim, and then I think appropriately, I want to give my fellow Democrat the last word, Allison. So Dan, we'll start with you.
Just very quickly. First of all, I don't like the phrase ESG any more than I like the phrase D, N, and I. I mean, these are politically charged terms. So I've started just referring it to the movement as sustainability, generally ESG as a subset, but sustainability is unassailable. That's managing business enterprise for long-term value creation. And I think if we keep the discussion on sustainability, a lot of these issues, the resolution becomes obvious. On the question of materiality, I agree with Allison. It is the number one issue from the investor perspective. And we have to remember that our history of corporate governance is largely a history of management disguising significant material risks from investors until it's too late. And we saw that obviously in Enron and WorldCom. We saw it more recently in Silicon Valley Bank. And so the onus really is on the management to provide disclosures on material risk factors for the benefit of investors. And materiality has to, for that reason, be viewed from the perspective of the investor. And then finally, I just want to say that, I've observed this movement for the last 2 decades evolve. It very clearly has as its primary focus climate change. And I would submit that there is no amount of corporate disclosure that is going to meaningfully move the needle on greenhouse gas emissions. If you really want to have an impact on greenhouse gas emissions, you have to harness macroeconomic forces in a much more fundamental way, such as through carbon pricing or carbon taxes. But that's for another discussion.
Yeah, very briefly. ESG, I think that it's obviously become a very hot political issue. I think that started, about a year or so ago when the individual states started to respond to what they thought or saw was going on in Washington and other places too, with regard to ESG. So I think that continues through the election of 2024. I certainly hope that after that we can start, for instance, back to the original bills we talked about, go back to some of these bills and look at them individually, and more importantly, the issues behind them. I do believe that there is some bipartisan support for many of the issues behind some of these bills. And so I certainly hope that going into 2024, regardless of who's in the White House and who's controlling Congress, that we're able to sit down both sides and be able to figure out what's best for investors and the economy as a whole.
Thanks, Tim. Allison.
Thank you.
Over to you.
Rather than sort of have the last word, I want to focus on what I agree on, because I think that's kind of what we're trying to do here. And so I'll start with this. You mentioned, I think it was Dan, or maybe it was Bob, this notion that in Europe, you sort of have what appears to be the regulators leading the markets, whereas in the US, you've kind of got the reverse. I think that's a much better place to be in general, because we were able at the SEC to leverage these private ordering and market-driven solutions in coming up with some, with a proposal. And it also really is a way of, if you think about the system right now of voluntary disclosure, what we're really trying to do is fix that. Find the places where it's not working. Where can regulators add value as opposed to lead the way? Where can we add value to what's going on? Then that comes in with comparability, consistency, reliability. So I think that model in general is a better model for capital markets. And I feel very proud of the SEC for having done that. But secondly, in terms of another place of agreement, Dan, your point about substantive regulation, I agree with 100%. That's not in our wheelhouse at the SEC or in their wheelhouse. I, purposefully keep my focus at the time I was there on the, what's relevant to investors and capital markets. But we need substantive regulation on these issues. carbon pricing, whatever it is, caps, I mean, that, Congress needs to step in and deal with this. That will make a much bigger difference. But it doesn't mean, in my view, that in the short term, you don't need transparency for investors around what the current state of affairs is. The point of this regulation is not to move the needle, but rather to allow investors to price risk and allocate capital as they see fit under the current circumstances. But moving the needle is important for where we are going as a planet. And I think substantive regulation needs to be, that should be a focus. And in fact, it was a focus, as you know, at the CFTC when they did that early report from their Market Risk Advisory Committee. That one of the first things they said was we need carbon pricing. And I agree with that 100%.
So listen, thanks, Peter, for the extra 5 minutes. Thank you, Dan, Tim, Allison, for your time. The panel's been fun, the waning days of summer. Allison, I'm looking forward to seeing you in New York for Climate Week. Dan and Tim, I'll see you in DC when Congress reconvenes, and we'll continue our discussions down there. So listen, enjoy the rest of the summer, and I look forward to staying in touch with all of you. Take care.